Same-sex marriage activists gathered outside the United States Ninth Circuit Court of Appeals for Perry v. Schwarzenegger, the federal case that overturned Proposition 8. Anti-gay counter-protesters crashed the party with large signs and verbal taunts over loud bullhorns. Raymond Donald Hong was there at the courthouse and will bring us more details later this half hour.
On December 6, litigants of Perry v. Schwarzenegger arrived at the James Browning United States Courthouse for appellate review of Judge Von Walker's federal court ruling that found Proposition 8 unconstitutional. Same-sex marriage activists gathered outside the courthouse at 7th and Mission Street with inspirational speakers from gay organizations and the faith community expressing why marriage equality is important to them.
We have those signs all over the place. The Episcopal Church welcomes you. Well, we mean it. The Episcopal Church welcomes you.
Same-sex couples brought copies of their marriage license and photos from their weddings to help illustrate the importance of marriage equality.
I think it was absolutely fantastic to have the amazing cross-section of supportive clergy speaking today from all different denominations, and they're not just, community people with a big sign, who knows where these people come from, but they're actually like congregational leaders from all the major traditions standing here for justice, for equality, for religious freedom.
Equal rights, equal all the way. Oh, what fun it is to sing for equal rights today.
Across the street and outnumbered by 10-1 were a handful of conservative religious counter-protesters shouting back with bullhorns attempting to overpower the rally.
Shame on you for even assuming you can have male-male marriage.
Molly McKay of Marriage Equality USA has no problem tuning them out.
I don't even really hear it anymore, believe it or not. It's just, it's the dying death knell of bigotry against gay people. They serve to really make our point. As far as I'm concerned, every time he speaks, he's underlining what I'm saying and bolding it.
Traditional marriage supporters and proponents of Proposition 8 argued that California voters should be the final arbiter of matrimony.
The will of the state of California said no same-sex marriage. And for them to do that, it is a spit in the face to democracy, the very core of what this country is supposed to be represented.
As a matter of constitutional law, the people must have a rational basis for the decisions they enact. And the court, as you heard, went into the questions of whether or not a basis can be articulated that is rational, that supports the people's decision. In the over 200 pages of briefing that we filed with the court, we have articulated multiple rational bases, and so that is really the end of the constitutional query. That is our position.
I have a problem definitely with the method the advocates of same-sex marriage are using. Instead of going through the constitutional amendment process, they're trying to reinterpret laws that were never there to protect a right that's never been granted to them.
When the foundations are destroyed, we become lawless and we make up our own laws. This always turns into tyranny, and tyranny always turns into violence.
I understand that a minority of the population, i.e. homosexuals, want to redefine marriage so as to include themselves and and otherwise a definition that has excluded them since the beginning of time.
Citizens have the right to make public policy decisions and to make policy decisions that are one way one particular year and another way another particular year. As a matter of constitutional law, the people, as the sovereign governors of this state, have the right to make that decision.
This counter-protester, who did not wish to be photographed up close, but here he is from across the street, believed biblical law supersedes the U.S. Constitution.
I will tell you that the Bible does trump the Constitution of the United States.
Can you cite any examples?
That's a good question. Can you please repeat your question?
Luke Otterstedt believes that there is a price tag on straight marriage and the dollar value has gone down.
When you have marriage between a man and a woman, that has meaning, that has value, and when you have something else added to that, changing the definition of marriage, expanding the definition of marriage, that actually cheapens the real thing. If marriage can mean anything, marriage means nothing.
It doesn't make sense for us to want to go into an institution to try to harm it. We want to go into an institution to fulfill it. We honor and cherish marriage. We're not fighting for marriage because it means something that will demean something, and we're not trying to change anyone's views or or create new rights. We're just trying to be part of an institution that allows us specific benefits in our lives and doesn't really affect anyone else if we're married.
I would have no other comment other than to say that we're confident that we would strengthen the institution because we've been together for 10 years and we love each other.
The 3 appellate court justices do not have a fixed time limit, but it is expected that their ruling on whether or not to uphold Judge Walker's decision will be made in a few months.
In enacting Proposition 8, the voters of California erected a fence around the most important relation in life, according to the Supreme Court, marriage. That is unconstitutional. It violates the fundamental rights under the Due Process Clause of the United States Constitution and the Equal Protection Clause of the Constitution, which says that our citizens are entitled to the protection of equal laws. Proposition 8 is not an equal law. We're looking forward to a decision from this court soon, we hope.
At the James Browning United States Courthouse in San Francisco, this is Raymond Donald Hong for Outlook Video.
The fight for marriage equality continues with a new twist in the federal court case decided by Judge Von Walker. The proponents of anti-gay marriage Proposition 8 want to throw it out. Raymond was also at the federal court building where Marriage Equality had their rally, and his report will come up later in the half hour.
A new twist came on the federal court case of Proposition 8 when attorneys for the anti-gay marriage proponents filed a claim to throw out Judge Von Walker's ruling that the proposition was unconstitutional. Attorneys for the proponents claimed that the judge's 10-year relationship with another person of the same gender would not make him impartial to the case.
Over 8 months after declaring unconstitutional the Democratic decision of over 7 million Californians to reaffirm traditional marriage, Judge Walker publicly revealed that he has been involved in a committed same-sex relationship for over 10 years. Instead of revealing these facts to the parties and their counsel, Judge Walker kept them to himself, even though the subject matter of the case presented an issue in which Judge Walker and his partner had a direct interest. Judge Walker's course of conduct in this case heightens the appearance of partiality. When judges rule on cases in which they possess a substantial and direct personal interest, there can be no justice. And when judges fail to disclose all relevant facts concerning the potential interest they may possess in the outcome of a case and permit the appearance of partiality, the entirety of our judicial process is undermined. Judge Walker's decision must be vacated and reconsidered by a neutral judge who has no direct and substantial personal interest in the outcome, and whose impartiality cannot be reasonably questioned, as required by federal law. Only then can the court ensure that this case will be decided in accordance with the high standards that apply to the judicial process.
Proponents argued that because Judge Walker was in a long-term relationship, then the issue of his intent to marry was applicable. Judge Ware said that there were no facts showing that Judge Walker wanted to get married, other than being in a long-term relationship. After lengthy questioning by Judge Ware, proponents' attorney Charles Cooper admitted that if Judge Walker didn't want to get married, then there would be no bias.
The intervening defendants' homophobic and bigoted motion, I think, will prove to be a real low point in American civil rights history. But it's our hope that Judge Ware's opinion and the ultimate decision in the issue that's before us today will end up proving to be a positive turning point and erase this dark spot that was put upon us by the intervening defendants today.
It harkens back to the days of the trial of Dan White for the murder of Harvey Milk, because in that trial they excluded the jurors who were gay simply because they were gay. And it's the sort of tactic that has been used against racial minorities, against women, against people of various religious faiths, to try to stereotype them, to try to marginalize them when they're jurors or judges. And we're very hopeful that this tactic will not work in this case.
This motion is a frivolous, offensive motion. It was deeply unfortunate that the proponents decided to file this motion. In some ways, though, it's not surprising, because throughout the civil rights history of our country, when judges from a minority group have sat on a case where there was an equal protection claim or some issue that related to the rights of that minority group, litigants have tried this trick. They've tried to knock the judge off the case
because of their status as a minority. And each and every time throughout our history, the courts have rejected those attempts. We're very hopeful that Chief Judge Ware will do that in denying this motion.
Within 24 hours, Chief Judge James Ware rejected proponents' claim that gay judges are less capable of impartiality, stating that their arguments relied on mere speculation and assumption. The next chapter in the case of Perry versus Schwarzenegger will be at the California Supreme Court in September, where justices will decide on whether the proponents of Proposition 8 have legal standing to appeal the case. In San Francisco, this is Raymond Donald Hong for Outlook Video.